Good afternoon, everyone. I'm going to call the meeting of the State Allocation Board to order. Ms. Jones, will you call the roll, please?
Certainly. Senator Wilk?
Present.
Senator Leyva? Senator Roth?
Here.
Assemblymember Nazarian?
Present.
Assemblymember O'Donnell? Assemblymember Cunningham? Juan Morales?
Here.
Cesar Diaz?
Here.
Daniel Kim?
Here.
Gail Miller?
Here.
We have a quorum.
Thank you. Before we start our agenda items, I wanted to welcome our new member who isn't quite here yet, but just to let you know that Assemblymember Jordan Cunningham is joining the board, and Mr. Gallagher will not be on the board. So we will hope to see him later and welcome him then. So I'm happy not to be the newest person here today. So next, Ms. Silverman, if you have the if you have the executive officer summary, please.
Yeah. Do you want to?
Oh, wait, do I want to do the minutes first? Yes, sorry. May we approve the minutes first from our last board meeting?
So moved. Second.
Moved by Senator Roth, seconded by Mr. Nazarian. Ms. Jones, please call the roll.
Senator Wilk?
Aye.
Senator Roth?
Aye.
Assemblymember Nazarian?
Aye.
Juan Morales?
Aye.
Cesar Diaz?
Aye.
Daniel Kim?
Aye.
Gail Miller?
Aye.
And that-
Thank you.
Motion carries. Thank you.
Great, thank you. Okay, now we're on to the executive officer statement.
Yes.
Thank you.
So we have a few things to share tonight. So we wanted to update the board on the full day kinder facilities grant program. And so we wanted to highlight last month, we took action on 12 projects for $37.5 million. We did share with the board last month that we had 261 projects for $324 million for the first funding round. So that was great news. Oversubscribed, definitely. Second filing round closed on May 30th, and they're competing for the $60 million that remains, and that's 349 applications that came through the door for nearly $432 million. So a lot of interest in the full day kinder program. So looking forward to provide those grants and those awards in the fall for the board to take action on. We wanted to give the board an update on the priority funding apportionments that reflects the spring bond sale. That's nearly $222 million in bond awards. And so those projects have until July 23rd to activate their program cash. And just to give the board an update, as of June 7th, there was about $110 million that has been dispersed. So they have, again, till July 23rd to come into the program cash. We have about a handful of projects with career tech education, and they have different timelines. So those projects have 12 months to perfect, so they have until April 23rd of 2020 to come in with the Division of State Architect approval and Department of Education approval as well. So we will continue to communicate with districts about their program cash, and I'm sure we'll see a rush of projects come through the door before the July 23rd deadline. And again, the goal is to activate all the program cash. We also wanted to highlight there was a priority funding round filing deadline that closed June 6th. We had nearly $777 million, actually over $777 million in projects that came through the door for that certification round. That was over 196 projects. So what that means is those projects are definitely eligible for the fall bond sale, and so those certifications are valid from July 1st to December 31st. And again, that's great news for the fall bond sale, and that's great news for those projects. The next item we wanted to highlight is we have a Career Tech Education Facilities Program stakeholder meeting, and that meeting is July 24th from 1 to 3. And that will be here in the state capitol in room 4202. And the goal of that meeting is to talk about the current funding order for the Career Tech program. So again, those we'll have a webcast, and we'll actually be producing our item in the public notice 10 days before the meeting. So again, looking forward to getting a lot of public input on the funding order for Career Tech education. And then we will not have a meeting in July, so just wanted to share that update as well. And so our next meeting will be August 28th at 4 o'clock.
Great, thank you very much. Is there any public comment at this time? No? Then we will move to the next item, which is the consent agenda, please. Ms. Silverman?
Yeah, consent agenda is ready for your approval.
Great. Are there any questions from the committee on the consent agenda?
Motion to approve.
Great. Thank you. Moved by Mr. Diaz, seconded by Mr. Nazarian. Any public comment? No? Great. Ms. Jones, please call the roll.
Senator Wilk.
Aye.
Senator Roth.
Aye.
Assemblymember Nazarian.
Aye.
Juan Morales.
Aye.
Cesar Diaz.
Aye.
Daniel Kim.
Aye.
Gail Miller.
Aye.
That motion carries.
Great, thank you very much. The next item on our agenda is the status of fund releases. Ms. Silverman?
Yeah, so if I can direct your attention to tab 5 and 6. So tab 5, we just wanted to share with the board on page 97 is just the activity of the bond sales being released, as I shared with you earlier. In May, we dispensed $59 million. And again, the board took action on the end of April for those bond proceeds. And so as we get closer to the July deadline, we'll show more activity come the August board. So that will reflect the $200+ million that we'll be dispersing. So that's great news. And then as part of the consent agenda on page 99, again, that's reflective of all the bond proceeds we do have. In the consent agenda, you did approve over $158 million in project awards, so that's great news as well. And we do have some closeout and rescission activity as a result of the consent agenda. So that's the highlight of the status of funds.
Great, thank you. Is there any public comment on the status of fund releases? No? Then we're going to move on to the status of funds, but we do that at the same
did that,
time.
yeah.
Yes, I did this last time too. Okay, then we're going to move to tab 6. And we're going to hear the Farmersville United, Tulare, and San Bernardino appeals together. Correct, Ms. Kampminer?
Yes, we'll
Okay,
do the staff
so-
presentation together, and the districts are also here to provide comments and
Great.
answer questions.
Thank you.
So with that, the first appeal is for Farmersville Unified in Tulare County, and this can be found in the appeals section on page 117 of your agenda. Farmersville is requesting to retain unspent funds from the completion of a new construction project at Freedom Elementary School. And a little history on this project, the district received an apportionment in December 2011 for a little over $4 million in funding to construct an 8-classroom addition. As is shown on the table on page 117, the state grant for the project was approximately $2 million, with additional financial hardship assistance in the amount of $1.79 million and a district contribution of $241,000. The district completed the project and in 2017 submitted the final expenditure report and declared $248,000 in unspent funds. In accordance with the SFP regulations, OPSC requested that the district either return the savings and have that amount reduced from the financial hardship assistance provided for the Freedom Elementary project, or apply the funds to reduce financial hardship assistance to a future project in the next 3 years. The district opted to appeal and requested to retain the savings for other high-priority capital facility needs. Staff does not support the district's request, as we believe that the request to retain savings is inconsistent with the language and intent of the statute and regulations governing financial hardship assistance. However, the district maintains that the regulation requiring the return of savings is contrary to how savings is treated in the SFP statute. And the district further maintains that the requirement for financial hardship districts to return savings is discriminatory. And for reference, the specific statutes that are the topic of this discussion are Education Code sections 17075.10, 17075.15, and 17070.63C, the text of which can be found on page 121 of the agenda for your reference. And the district relies on Ed Code 17070.63C, which states in part that any savings achieved by the district's efficient and prudent use of funds shall be retained by the district for other high-priority capital outlay purposes. And for projects under the SFP where districts are making their matching share of funds, OPSC acknowledges that savings can be retained by districts. However, the district maintains that this statute should also apply to financial hardship projects, and that therefore the regulation section, SFP regulation section 1859.103, which requires the return of savings, is inconsistent with the law. We disagree with this assertion. The function of the financial hardship program is to enable districts to participate fully in the SFP. It allows districts who qualify to receive additional funding from the state based on a district's financial constraints. And statute provides the board with distinctly separate authority for financial hardship under Ed Code sections 17075.10 and 15. And those sections further include the authority to adopt regulations to determine the amount of funds that will be provided through financial hardship funding. When the board did adopt regulations, it required that savings would be returned, and that was done under the Education Code, which specifically states that the board shall adopt the regulations to determine the amount that may be provided and the eligibility under the article. And the regulation does identify that the unspent funds may not be retained for other high-priority capital projects. So the district's claim that the regulations are inconsistent with statute does not appear to consider the authority provided under this particular statute. So we believe that the regulation requiring the return of unspent funds from financial hardship projects is legal, and that the board's authority to create a regulation to require this is clearly provided for in Education Code. And this is how financial hardship's been handled for almost 20 years. The program was intended to assist the districts in providing their matching share, and it was never intended to leave hardship districts in the position of retaining unspent grant funds after the completion of the project. We've discussed this at length with legal counsel, who fully concurs that this is the correct application of Ed Code Section 17075.15 and the related regulation. With that, I'd like to transition to San Bernardino's appeal, which begins on page 143 of the agenda. The project, so that the specific arguments we just discussed here with relation to FARMERSVILLE are also related to the San Bernardino appeal, and then the San Bernardino appeal has a few other areas for consideration. But the project up for discussion is for an overcrowding relief grant project at Middle College High School, and that was from funding that started with Proposition 1D. And the district did receive an apportionment in February 2010. The project funding summary, it's on page 144. And that table will show that the total project cost was $35.7 million, with a state share of $17.9 million. The financial hardship funding was in the amount of $17.7 million, and there was a district contribution of approximately $200,000. The district completed the project and submitted the final expenditure report in July 2015, which indicated unspent funds in the amount of approximately $3.2 million. Like FARMERSVILLE, the district is disputing the requirement to return the funds or to use them to offset financial hardship on a future financial hardship project. So for the other, in addition to the statutory discussion, the district has raised a few other areas for consideration. First, the district maintains that because their project was funded under the Overcrowding Relief Grant Program, that the Santa Ana Unified School District versus State Allocation Board court case can be used to justify its appeal request. Staff acknowledges that the Superior Court did indeed decide on the matter of savings in the Overcrowding Relief Grant Program. However, the court's decision did not include consideration of the statute related to financial hardship funding, and that was because Santa Ana had made their local match for the project that was the subject of the lawsuit. So we maintain that it is the financial hardship regulations that require the return of the unspent funds, which is separate from the regulations concerning the Overcrowding Relief Grant Program. Secondly, the district also points to a memo from 1999 issued by OPSC that states that districts that have savings on a financial hardship project can retain them for purposes of other high-priority capital outlay. And we have researched this memo and reviewed OPSC's and the board's past practices and procedures after this memo was issued. The memo does appear to be a misinterpretation of the financial hardship regulations. It also appears to be the only time that it is mentioned that financial hardship savings can be retained, and subsequent guidance from OPSC just 3 months later, and actually every publication following, a sampling of which we've included on the agenda on page 147, does provide the correct application of the regulation and that savings must be returned. So we do not support the appeals, and we maintain the position that financial hardship assistance was only intended to help districts who could not make their matching share so that they can participate fully in the SFP. To date, approximately $166 million has been collected in unused financial hardship funds, and it's been returned to the program and reallocated for other construction projects. And as I mentioned before, we've worked extensively with legal counsel, and we do believe that the board was on solid ground back in the beginning of the program when they established the financial hardship regulations, and that the regulation is in keeping with the goal of financial hardship assistance. With that, I'd like to turn it over to the districts too.
Thank you very much. Would the districts like to make their way up here, please? And Mr. Cunningham, welcome. This is my second meeting, so I'm very happy not to be the newest person, but I've already messed up once, so. Thank you. Welcome. If you could please state your names as well.
Paul Saviano, Superintendent,
Great, thank you. With,
Farmersville Unified.
great, thank you.
Nick Clare, Legal Counsel for FARMERSVILLE Unified.
Phil Henderson, Legal Counsel for San Bernardino City Schools.
Thomas Pace, Director of Facilities, San Bernardino, and I appreciate the sign that says, "Don't sit on the glass." I thought about sitting on the table myself.
Is it really?
No, but I appreciate the guidance, though. It's very clear.
It says it up here as well. Well, thank you. Go ahead.
I would like to thank you for hearing our appeal today. My name is Dr. Paul Saviano, Superintendent of Farmersville Unified School District. Farmersville Unified is a rural school district located in the Central Valley. 91% of our students are qualified for free and reduced lunch, and 43% of our students are identified as English learners. Our appeal today is based on the following. In 2012, the district received state financial hardship funds to add an additional building to Freedom Elementary, which moves sixth grade students from the junior high school to relieve school overcrowding. District staff used hardship funding strategically and realized the savings of $248,000 on the project. The district used the savings on another modernization project to resolve a costly change order to address discovery of underground storage tanks and removal during a replacement of air conditioning in our cafeterias and restroom upgrades to meet Williams compliance. Because hardship funds were expended on high-priority facility needs, the district will be forced to return the savings from our general fund, which will impact the district programs that benefit our students. The district was surprised to learn that an inconsistent exception to the legislature's statutory rule that applies only to financial hardship districts. Had the district known at the time it would be required to return the savings realized on the project, the district would have added additional classrooms and other less high-priority improvements to the project. It would be imprudent for the district to not make use of every dollar available. And faced with a use it or lose it choice, we will of course use it. Instead, the district took the action the legislature intended and utilized the savings we realized through our own efforts on other urgent facility needs. It is unfair that wealthy school districts are rewarded for prudent project management, while we are encouraged to spend funds on unnecessary single projects rather than addressing the critical facility needs and infrastructure needs of our district. In our case, the district did exactly what the legislature intended. We made every effort to control costs and to prudently manage the project, and as a result, we were able to address other critical facility needs. We did not do what the State Allocation Board's inconsistent policy encouraged, making unnecessary expenditures on a single project while ignoring the other critical infrastructure needs of our district. The Office of Public School Construction requests for the return of the project savings at this stage will impact the district's general fund and impact important programs for our students. We hope that you fully consider this policy of unequal treatment of less advantaged school districts that will impact our students and similarly situated students statewide. Thank you.
Thank you very much.
Once again, my name's Tom Pace. I'm the Director of Facilities for San Bernardino City Unified School District. I bring the message of our superintendent, board, and community here this afternoon, and like to largely thank those that we've sat with and discussed our point of view for your time and effort in understanding our perspective. And I think understanding how the org projects are funded is important to understand our argument. When you look at the org program, it is a 50-50 program for new construction. 50% coming from the state, the grant share, and in order to qualify for the grant share, you have to have eligibility or entitlement. And there's an exchange that occurs. And giving that eligibility, this alternate currency, you get state funds. You get 50% of the project. Under hardship, we proved that we had the inability to raise local funds. We received hardship funds to make up the remaining 50%. We had $3 million in savings. We inquired as to how OPSC treats savings. They treat it the same way from the two separate pots. So if you have $3 million left over, 1.5 of that is considered state share, grant share, and 1.5 is considered local share. And you may be wondering why we're trying to retain savings, given that we received the benefit of a new school. And I think that that's a fair question to ask. And I hope largely to answer that question right now. So in non-hardship, savings is looked at the same way under the org program. If a district, the neighboring district to ours, has savings of $3 million on an equivalent project, the savings is considered 1.5 million state share, 1.5 local share. What that district can do, non-hardship can do, is they can take that $3 million in savings, put that back into another qualifying project, and receive an additional $3 million in state funding. In the end, the district next to ours can build another project for only $1.5 million of local contribution. What we're told is, you got a new school, return your money, and we will not return eligibility. I think what's lost in this argument is the state share is given in exchange for eligibility. It's punitive to hardship districts to ask for those funds back. And I'll tell you why it's punitive. When we lose eligibility, we lose the ability to get back into the program. And while our neighboring school districts can build with their savings, and the example I gave you on non-hardship for $1.5 million of local savings, a neighboring district can get an additional $4.5 million in state funding. When we're asked to return the state share, the local share, and we do not get eligibility back. What we are telling the students of our district and small school districts is that because your parents bought a home in an area that does not see assessed value growth, you do not get the same value of education that neighboring school districts can. Classifications based off of wealth are inappropriate. The idea of returning savings does not help us meet the need of our school district. We serve over 50,000 students. 5,000 of them are homeless. The idea to return savings back to the state to fund other projects outside of our area, we feel is inconsistent with statute and with case law. And that's essentially why we think that we should retain savings. We think that allocations, once made, are full and final. Our governor even made the same argument with the federal government over the bullet train. He said once Congress allocates money to the state, it needs to stay in the state. It does not go back. That idea of once allocated should hold true. And I think that one of the things we also forget is the citizens of our two communities pay taxes. The bonds that the state issues are paid for out of the general fund from taxes generated from our communities. To return savings is punitive to our two communities. And our two communities serve high-need students, and I think that that's largely what we believe is that it's inconsistent with statute, case law, we have need, and the allocations were made.
Thank you for your time. Are there any questions from the members?
Yeah.
Mr. Nazari?
So do you have a project ready to go?
Yes, sir.
So do you have a project that you've applied for at this point, that you can apply these funds to?
We have high capital projects that we're in design for that we could apply these funds to right now. And in my mind, the org funds...
I'm sorry, have you applied for it yet, though?
The
Is
org program is
application-
closed. So for us, we would have to apply either in modernization or new construction.
Right.
But this has been going on for some time, so why not, why haven't you applied so that then we can consider whether or not the money, because we have made that exception, we have approved appeals like that, but if there's nothing in queue,
We have projects that are in queue.
But I think...
Modernization, but the org program is closed, which I think is another point, is we're returning funds back to a program that is closed. There is no ability for districts to apply for org
Right.
projects.
I'm going to actually correct that.
Yeah.
So the $166 million, this is a practice of over 20 years, as you know. I think FARMERSVILLE has actually returned hardship savings before on 4 different occasions, and And while we understand that the need in each district is so great, part of what we face as a state is how do we get the most amount of money out to the most amount of districts? So the $166 million that has been returned to the program, and I'll rely on Mr. Patton and staff to correct me, but it does go back out. It doesn't, and that is part of the state's role, and there's always attention, as we know, in making sure that the state actually serves the maximum amount of schools possible. So I do just want to point out in San Bernardino, of the $35.5 million that you have for this project, the district only contributed $196,762.
We contributed eligibility for our state share.
Right, absolutely, and I'm not disagreeing with that, but I do want to, the issue here, to Mr. Nazarian's point about other projects, doesn't only speak to San Bernardino or Farmersville. There's also a broader question about the huge need in the state that is really, really significant and is much greater than any one of your districts. Ms. Silverman, do you want to say something?
Could I quickly respond to the larger
Let Ms.
impact?
Silverman, just
Oh,
to make
sure.
sure I got it right, because again.
So I do understand there's two issues here. So there's $9 million currently in the Overcrowding Relief Grant funds that haven't been allocated. We have two projects that haven't been dispersed because we are waiting for the disposition, not only of this appeal, and we have program funds. So depending on the outcome, so we left the program open, and there's two projects waiting on the workload list. And those projects are listed in the information section on page 314. That's Covina Valley and Chafee. And those are overcrowded relief unprocessed grants. So depending on the outcome, those projects potentially could get funded.
Right. And one final point. I don't want to conflate the overcrowding relief with the financial hardship, because this appeal specifically applies. We're kind of conflating the two, and what this appeal is based on and the law it is based on is on financial hardship and not overcrowding relief. So I do want to keep those two items discrete. And I'm sorry, sir, please.
No, and I think I would agree with you on two items.
Oh, good.
So let's agree on the fact that statewide we have lots of need. I would ask the question, if we're concerned about need and funding other projects, why do we allow other districts to retain savings that were generated from the state? If we want to allocate greater,
And that's why I was asking if you had a project. I'm sorry, I'm speaking out of turn, Mr.
No,
Chair.
no.
That's why I was asking if you had submitted. Thank you. That's why I was asking if you had submitted a project and you had something in queue, because even if it was submitted later than most other projects have been in queue or already approved, the fact that you're already in the process, we've approved funding for other school districts in that manner, so that, if you've done a great job with savings, then it goes back and you can continue financing your projects. But
and we have projects in line. Yes, sir.
I don't think that's the case. Am I mistaken here?
It would be applied as an offset to any future financial hardship as opposed to any additional funding. And the Overcrowding Relief Grant Program, this is the only two projects that are left are those two that are on the list. We are not accepting any new applications for the Overcrowding Relief Grant Program.
Mr. Patton, and then Mr. Kim, and then Mr. Diaz.
I just want to interject. For me to be able to follow the argument and the discussion, it's very important that there not be a conflation of project types.
Right.
And so when the question is asked, do you have another project in queue? The answer is going to be, of course we do. The question, though, is, do you have another qualifying financial hardship program in queue to which you can redirect these funds?
Oh, thank you for that.
So the answer to that
Mr.
question, Tom, I appreciate the clarification, is no.
Thank you for that. Mr. Kim?
Thank you. Appreciate you traveling all the way out here to talk about this. It seems like there are two separate issues. One regarding you want to keep your money, and two is you want to retain eligibility. Okay, so with respect to keeping money, it sounded like from the initial testimony that this was a surprise that you wouldn't be able to retain the funds. But our understanding is you just returned monies on two other projects within the past couple of months. So it doesn't seem like it was a surprise. So it would be inconsistent for us to actually approve this, and would be inconsistent for you to actually receive the funds. So it seems to me that you knew what the the program intent and what the policy has been for the past 20 years. That's one thing.
So when you say you, because we have two parties, I'm assuming the district that returned funds on recently last 2 months is Farmersville?
Yes.
Okay, gotcha.
Okay.
Just want,
I'm sorry. I'm sorry. You're from San Bernardino.
just want to make
Yeah.
sure that we were
So-
clarifying the royal you.
So it seems like there were, okay, so I'm sorry, I got those two wrong. So in terms of keeping the money, we don't do that typically. We haven't done that for the past 20 years. I think the board has seen the hardship funds as different from the other matching funds because basically the matching funds, there may be an incentive to keep the money. You already have a large local match associated with that. So there may be there's a difference there versus having pretty much 100% funding. You have a match on top of a match, and any excess funds there, it would seem like that money should go to other schools that qualify for hardship. Because like Ms. Miller said, there is so much need out there. There's so many more hardship districts than there is funding available. So that's one thing. The other thing is, in terms of eligibility, I think we can talk about that. But I guess it comes down to this is oftentimes zero sum. So my understanding, just looking at page 314, in your own district, if the funds were returned back to the program, a school within your own county would be receiving those funds. Is that correct?
Yes.
Well,
Can I make
funds we would return would go, oh, okay, Chafee, I see what you're saying. Gotcha.
if I can make a quick
So-
point, sorry, go ahead,
To
Madam
this
Chair.
point specifically, and then we.
Yes, to his point specifically, because he reiterated the point you made, Chairwoman, is, again, these savings are desperately needed from districts. I guess nobody's addressing the point that you're only doing that on the back of the financial hardship districts, the poorer districts in the state. All the other districts in the state get to keep the savings. There are needs in this state.
Well-
The program works that savings get to be kept by the districts, and everybody has eligibility that they use. And financial hardship districts are just like those districts. But all of the savings comes out of financial hardship, which
I'm
are
gonna
the
make
needier
a
districts.
I'm going to let Mr. Diaz speak, and I'm going to
Absolutely.
clarify that point about how the math actually works and
Mm-hmm.
how financial hardship districts may do better.
Thank you, Madam Chair. I'll let you do that because I was going to point out something,
no,
the
please.
differences of the program as well in terms of the matching funds and the financial hardship districts actually receiving more money. And so per the regulation and even we're talking about the statute, you are receiving more money to actually accomplish your programs. And so we would like to see those other districts actually receive that kind of funding as well. But one mentioned about the statute and how the interpretation doesn't really correlate with our legal counsel's interpretation and 20 years of actual board practice and policy to actually distribute back into the program and then distribute within the county. What exactly in the statute and in the regulation do you see an inconsistency with? Because I don't really necessarily see that.
I will absolutely address that. The regulation is unenforceable because it does violate the statute. You are absolutely correct that the statute allows you to implement regulations, to implement the statutory requirements. 7563 specifically states the entire program, districts get to keep savings, and neither .10 or .15 allow you to override that statute. Yes, you can write regulations that implement it, but the regulations can't violate another statute, and that statute still exists. And if I can make, sorry, go ahead.
Finish your point, but I would like to ask Representative Prilovich, through the chair, can we ask Mr. Patton to actually respond to those?
You made another point at the beginning, Mr. Diaz. At the beginning that you stated the district is in essence getting 100% of the funding. I understand that. And for other districts are getting 50%. I don't remember OPSC offering us 50% of the savings. They want it all back. Every other district gets to keep, in essence, what you're saying is 50% savings because they contributed the other 50%. But for financial hardship districts who financially could not come up with the money, you're saying give us 100% of the savings back. That is a disparate impact and disparate treatment of districts that are, frankly, poorer than non-financial hardship districts.
I'm going to actually let Mr. Patton respond.
Okay.
And then if you wanted
Yes.
to add something.
Oh, absolutely.
after. Thank you.
I like listening to Mr. Patton.
Thank you. By way of background, and I think some of the people here know, I have not gotten to know every member of the board, but I've been working with the program for about 12 years, since 2007. And when I was a Deputy Attorney General, and I was litigation counsel to OPSC and to the Allocation Board. And I went through a long piece of litigation over financial hardship funding and claims of violation of equal protection under Serrano versus Priest. And that culminated in a District Court of Appeal, 4th Appellate District, Division 2 decision in Monica Sanchez versus State of California, November 19, 2009. And the argument was made there that these hardship district children cannot be disparately treated. They have to be, the argument was that the formula for funding was inadequate to get them to the level of the wealthiest districts in the state. And I'm here to tell you that was flat out rejected by the Court of Appeal. The question is not, does a hardship district have the same amount of funding as Beverly Hills? The question is a constitutionally adequate level of education provided as required by Serrano versus Priest? And we pointed out the question is not, it's interesting when I hear the argument we're being treated disparately. Well, financial hardship districts are being treated disparately. They're receiving more grant monies than any other districts. That's the disparate treatment. And the premise of this program is that any monies that are not needed to fund both the state and the local match share, which has now been made by the state, any of those monies go back to the fund to fund further financial hardship projects, which is why it's very important not to conflate the types of programs. I don't agree at all with the argument that the general statute 1707063C that talks about any savings achieved by the district's prudent expenditure shall be retained by the district, for the reason that 17075.15 did very expressly give the board the authority to adjust or defer the local financial contribution and to adopt regs to determine the amount of funding that may be provided through the hardship program to a district. So I have advised, and I will continue to take the position that the board is authorized to have adopted 1859.103 as its governing regulation. And the equal protection argument, to me, is it's a red herring. It doesn't fly. As long as Serrano versus Priest mandate of a constitutionally adequate education is provided, the hardship program is satisfying constitutional standards.
So could I ask you a question, sir?
Sure.
So hardship, there's two types of hardship. There's facility hardship and financial hardship. Would you say then that both of those two exceptions should return savings?
That's not the issue.
Because the hardship provisions, it's not talking solely about financial hardship, it's talking about facility hardship and financial hardship. So would you say that savings has to be returned in both cases?
I would have to ask Ms. Silverman to clarify, because now I think we're going to conflate two concepts here.
So I think I'm going to actually bring it back to the board. I think some of these conversations, Mr. Patton is obviously available. So are there any other questions from the board? Mr. Morales?
We are very sympathetic to the position that districts who achieve project savings should be able to reinvest them into other projects. However, granting this appeal would invalidate our board's regulations that hasn't just been approved by this board, but they've also been approved by the Office of Administrative Law, and they've been in effect for years. What we would propose, we would be open to having a discussion of future regulatory changes if the board would so choose. But because we have this regulation that's been in place for years and has been enforced in other districts, we believe that we're bound by this regulation.
Thank you for that. Any other questions?
respond to that?
Why don't we let the
Okay.
board ask questions, and then we'll come back to you for a response. Thank you very much. Senator Wilk? Nothing? Any other questions from the board?
Okay.
Please, thank you.
So just on that last point, because this is something that, I'm sorry. Just on that last point, the Sacramento Superior Court in the Santana decision wrote, the board's argument in opposition to the petition make much of the fact that the regulation, same regulation at issue here, was validly adopted with no public comment until now. However, the fact that the public may not have opposed the regulation is no reason to accord deference to the board's interpretation. So just because something's been done for a long time or that it has Office of Administration review doesn't mean that the regulation's valid. And I kind of want to get back to, oh, I'm sorry. I want to get back to the regulation itself, because it doesn't just say that all savings shall be retained by districts. It says all savings that are realized by the efficient and prudent expenditure of state funds shall be retained by school districts. The legislature, in creating the statute, put its legislative intent within the statute. The legislature said, we want to encourage school districts to retain savings. All school districts, all project types, no exceptions. This regulation creates such an exception. And I want to hammer on that a little bit, because the purpose, what we keep getting at, or what I keep hearing, is that we want to have as much funds available to as many projects as possible. The legislature could have done that. They could have required savings to be returned. In all cases, in some cases, they could have let the State Allocation Board create exceptions. They could have wrote that into the regulation. And the regulation, I very much disagree, allows the regulation, or sorry, the statute that you rely on for the creation of this regulation, I very much disagree, provides that authority. And in fact, the regulation at issue here itself does not cite that statute as the basis of its authority.
Thank you for that. So I'm going to get back to my little math explanation. So I think what's at issue here is we're talking about all districts in general, but those that receive financial hardship assistance receive effectively more funding, because you're getting beyond the normal 50 or 60% of a project at the time the award is allocated. So I think when we talk about savings at the back end, you have to remember that 50-50 initial match. And so I'm concerned about when we're talking about the intent of the legislation, it's not just one section of the legislation or the regulation in isolation. It's a matter of understanding the entirety of the program. And so that's where, sorry, microphone, and then I'm going to let both of you comment and then see if there's a motion from the board on, and we'll do them separately.
And your point is very well taken. And the reason why that was written in that way is so financial hardships can have full participation. By taking 100% of the savings back, we are not fully participating in the program. You're taking the money, and Mr. Pace's example at the beginning was a very good one. His neighboring district gets to use those funds.
Right.
You're taking them back for another district. That's not how the program works. If we get full and final amount at the beginning, determining the amount of funding, which is what you're allowed to write a reg for, that's the full and final apportionment at the beginning. That's not determining the use of the savings. That's not what the statute was supposed to allow.
And the
Final comment?
yeah, the regulation, the idea that the regulation is to extend the greatest number of funds isn't even accomplished by the regulation. You create a system where you're encouraging school districts to spend every penny so that they don't have to return savings. And so you're encouraging wasteful spending by the school districts, which is exactly what the statute, when the legislature created it, was trying to avoid. They were trying to encourage the efficient and prudent expenditure of funds, not a system where you're encouraged to spend every dollar on every last thing, add every classroom, do some extra landscaping so that you don't have to return savings. That's what the legislature intended. This regulation is entirely counter to that.
Despite the fact that Farmersville has returned funds 4 times and San Bernardino has returned them more
There's a
than once.
cost to making these appeals, and that cost is not always greater than the amount of savings at issue.
Okay. Any final questions from the board? So I think we'll take them as 2 separate, is that correct? Yeah, okay, so we'll start with Farmersville. Is there any other public comment? Anyone in the audience that wants to speak? No? Is there a motion?
I'll make a motion to go forward with the staff recommendation that the district be required to return the excess funds declared from its financial hardship project.
Second.
Can we
So that,
please clarify, staff?
staff's administrative action was to require the district to return funds, so we don't actually need a motion to do that if there's no motion. Alternatively, staff's action stands.
So, Mr. Kim, would you like to withdraw your motion then?
I will withdraw my motion.
Thank you. Okay, there is no motion. So we'll move on to San Bernardino. Is there any additional public comment for San Bernardino? Seeing none, is there a motion to grant the district's appeal? There is no motion, but we thank you all for being here this afternoon and for your time. and
We
coming
appreciate
up.
your time.
Thank
Thank
you
you,
very
ma'am.
much. Thank you.
Thank you, Tom. You got a good name.
Next on the agenda is the Biggs Unified Appeal. Ms. Kampminer?
Yes. So our third appeal is for Biggs Unified in Butte County, and it begins on page 181 of your appeals section. This is also related to financial hardship, but a slightly different issue. The district is requesting that the board grant financial hardship assistance what is called other evidence. If you go to page 183 of your board item, it will show you the criteria that are considered when determining whether or not a district is eligible to receive financial hardship assistance. This starts from statute and then further has regulations identifying the process. And the first step is for a district to be levying the maximum developer fees. And then there are 4 other secondary qualifying criteria. The first 3 we can do administratively at the OPSC level. And if the district does not meet the first 3 criteria, then the 4th option is to come before the board with other evidence. The criteria include whether or not a district has passed a bond, a Proposition 39 bond for the maximum amount possible in the past 2 years. In the case of Biggs, the district has been unable to pass a local bond in their 4 prior attempts. The next option would be for a district to demonstrate that they have a total bonding capacity of $5 million or less. For Biggs, they are at $17.1 million, so they cannot come in administratively under that option. And the third administrative option is to have a bonded indebtedness of at least 60% of the district's total bonding capacity. And the district's currently at 0%, so we cannot do that administratively either. Little info about the projects. These are modernization projects for 4 school sites, and the total amount of financial hardship assistance being requested is a little over $3 million. The district does have, in addition to that $3 million request, the district does have about $436,000 in cash on hand to contribute. The district is requesting other evidence due to a few factors, one of which you can look at page 182 and see the history of the district's attempts at local bonds beginning in 2008. And in February and November of 2008, the district did go out to its local community and attempt to pass a bond to provide its matching share for the modernization projects. Those bonds did not pass, and in 2009, end of 2009, and it actually carried over to January 2010, the district appealed before the board requesting financial hardship, other evidence for that factor, as well as a few other things with the district's finances at the time. At the time, the board had a robust discussion about the financial hardship, other evidence approval and debated the issue. Some of the concerns raised included whether or not the state should provide assistance in cases where a district does not pass a bond, and if that's a valid reason for financial hardship, other evidence. Ultimately, at that time, the decision was to provide design-only funding so the district could get started on these projects and then go back out to their local community and attempt another bond. So the district did do that. They've got their plans designed and approved. They submitted their construction applications. They attempted in 2012 and most recently in 2018 to pass the bond at the local level. However, those attempts were unsuccessful, which is what brings them back before the board today. A few other things that we have looked at and explored with the district is related to their ability to explore other financing options for these projects. Perhaps a certificate of participation or any other options available. They have included a letter in their appeal from the Butte County Office of Education, which discourages the district from taking on additional debt. They ran a scenario, I believe it was about $3.7 million, which is roughly what they need to complete the modernization projects, and that would be an annual payment of about $250,000, and the COE discouraged that. We did also hear from the district that they are expecting to have some housing coming in from FEMA related to the families that were displaced by the Camp Fire up in the Paradise area, and that these students will be attending two school districts, Gridley, and then also overflow from whatever Gridley cannot accommodate, as well as districts that will end up residing within the Biggs unified boundaries. That would lead to students attending the schools. However, we did note that these are modernization projects, so the work being done will not actually add capacity for those students, but it will enhance the facilities that the students would attend, both the Biggs students and the Paradise students. We've also included on page 182, it's actually page 251 and 252 of the agenda, a past history of where the board has been on prior appeals related to other evidence, and it's been a bit of a mix depending on the individual circumstances of the district. The board has approved some, denied some, approved design-only funding for some appeals. So it's really been dependent on the individual circumstances. The last two appeals that we have heard related to financial hardship, other evidence in the last, in 2017 and 2018, related to districts that had some unique circumstances. In one case, it was related to a health and safety issue. And the board granted design funding and then then the district went out and passed a bond. Then the other case, it was a combination of federal funding being at risk, along with being just over that $5 million threshold, which hasn't been adjusted since the inception in about 2 decades, as well as having the unique circumstance where the school is on a military base, so all of the families were driving in and the voters were not attending that school. So that was factored into the past appeal as well. We are unable to administratively approve the district's request. The board, they have to come in under the board for other evidence. So this does appear to be standard modernization work, and the circumstances that are different from when the board grappled with this in 2009, 2010 appears to be pretty similar in that the district's local community still does not support the bond, but they have gone out 2 more times to try. There are 2 options for your consideration on this appeal if the board is inclined. So the first option would be to grant the district's request for funding for unfunded approvals, including financial hardship. However, if the board does not choose to go down that path, the district would still be eligible for modernization funding for these projects on a 60-40 basis. So they're still eligible for the state share. And that is the second option, to approve those items with the 60-40 matching share. And then that would allow the district time to figure out at the local level how to move forward with the projects. With that, I'm happy to answer any questions, and I believe the district is here as well.
If the district would like to come up, and does the board have any questions for Ms. Kampmeyer? No? Thank you. And if you could also please state your names for the record. Thank you.
Doug Kalen, Superintendent, Biggs Unified School District.
Pam Reagan, Financial Officer, Biggs Unified School District.
Alana Cunningham, Jack Schrader and Associates.
Please, go ahead.
As I stated, my name's Doug Kalen. I'm the Superintendent of Biggs Unified. First, I'd like to thank you for taking the time over this last week to hear our issues within our district. Biggs Unified School District is a small rural community in central Sacramento Valley with a population of about 2,000 people. We're located about 60 miles north of Sacramento, 30 miles south of Chico. The schools serve as a focal point for many community activities. School facilities are used by our community and are an essential part of the social fabric of our community. While the school district always prides itself on maintaining our facilities, eventually age takes over, similar to my foot, I guess. Our permanent facilities are over 50 years of age, and our portables are 20 years old. As you've been informed, the district requests for financial hardship approval under other evidence for funding of our modernization projects. In 2010, the SAB approved the district for design funds under other, and the district was required to attempt a bond. We've tried bonds twice for our modernization period since that time and have been unsuccessful. The OPSC states that only supports requests for financial hardship status under other in unique or severe circumstances. The Biggs Unified School District does have a unique or severe circumstances evident by the following. Our district is located in a have and have not community comprised primarily of farmers, owners, and workers. where 67% of the district students qualify for free and reduced lunch. Students who are socially economic disadvantaged and in need of the most support are further disadvantaged by being housed in substandard facilities through no fault of their own. The daily school experience is a critical factor in their sometimes fragile lives. All of our district permanent facilities are beyond 50 years of age and are in desperate need of repair, and our portable buildings are beyond the 20 years of life expectancy. The district has a strong sense of pride and maintains facilities as best that we can with limited facility funding, but the facilities are now requiring significant infrastructure upgrades due to their age. Biggs Unified School District is adjacent to the Camp Fire, as mentioned earlier, the most destructive fire in the history of California. A total of 540 FEMA trailers will be going in our area. 450 of them will be in our adjacent community, and 90 will be going into Biggs. 450 of those trailers are scheduled to be in place by August, just prior to school starting. Based on our primary estimates, there could be possibly 590 students K-12 generated from that housing project. The district has unsuccessfully attempted 4 bonds. The district facilities needs go beyond modernization eligibility. Therefore, bond amounts exceed the district's matching share. As stated earlier, the Butte County Office of Education has advised strongly against us issuing a COP in the amount due to the negative impact it would have on our district, and it is not sustainable for our district to make long-term debt service payments. The state has invested $628,000 in the district, has contributed $70,000 to draw plans for modernization. The plans have been drawn, and we have made every attempt to provide our match. Based on unique circumstances, we request financial hardship status under other. The facility hardship funding request for the approval of this appeal is a little over $3 million. The district has $435,799 available out of our capital facilities for this project. While any single element on this list may not create a unique circumstances, the cumulative effects of all 3 of these elements are free and reduced numbers, our unsuccessful 4 attempts to pass a bond, our inability to issue debt, and the impact of the most devastating Camp Fire create a unique circumstances. We respectfully request that you support our appeal. Thank you for your time.
Thank you. Any other comments? No? Thank you. Oh, please, may I get questions from the board and then open it for public comment?
Well, I'm the assemblyman that represents.
Oh, please, sir, I'm sorry. Of course. I'm sorry, Mr. Gallagher.
That's all right. Yeah.
This is what happens when you abandon us. Thank you, Mr. Gallagher.
So just briefly, to the board, I think that, the key question here is, are there unique circumstances presented by this appeal? And I think there definitely is. As we heard earlier this year, the Paradise Unified School District, the need to expedite that bond money because of everything that's happened in Paradise. What has also happened is, in addition to trying to help Paradise School District get back on its feet, many people have been dispersed into the outer communities. So here just next week, 1,300 people are moving into a FEMA site in Gridley, which is in Biggs and Gridley are right next to each other. The school district serves both areas, and so there will be an impact to this school as well as many people are living, outside of Paradise in the region, and we're experiencing these very real impacts to all of our facilities. So I think that spells out the unique circumstances in this case. In addition to, this is a district that has tried multiple times to try and pass a local school bond, but it is an area where a lot of people are on fixed incomes. I think, as was pointed out, there's a very high level of free and reduced lunch, and so it is hard to convince the community to add an additional cost on top of them. And again, I think they've done it both in 2008, 2012, and just this last year in 2018. It's not like they're not trying to get that local match. They've been really working hard to get that. So I just think with all those things considered, I think it spells out those unique circumstances category to grant this appeal. And so I just ask for your special consideration of what I think is a very unprecedented case. Yeah, thank you.
Thank you very much, sir. Please stay. Thank you. Any other questions? Yes, Mr. Cunningham.
Yeah, I have a few questions for the gentleman from Biggs. So there's FEMA trailers that are housing families that have been displaced by the fire, correct?
There will be.
There will be, okay. When are those going to be placed?
First phase, the 450 trailers are due to be occupied August 15th.
Okay, and then
There's 90 going into Biggs, and those, they haven't given us a date on those.
Okay, and then so your estimated number of students that are going to be matriculating to your district based on the trailers that will be sited within your district boundaries is what again?
Students going into the FEMA housing that is in Biggs Unified, which is about 7 miles away, they're anticipating, based on the number of trailers, the socioeconomic data, that there's possibly 450 students from those.
Okay, and so as I'm looking at page 188 of our materials here, and I believe it's your application or your appeal request, and it sets forth some factors and what you're seeking to use these funds for should your appeal be granted and you get them. And I'm seeing replacing roofs, modernizing HVAC, modernizing restrooms and buildings to be ADA compliant, and replacing 20-year-old portables. So is it fair to say that these things that you're listing here that you would use these funds to do are things that would benefit both the new students that are displaced from the fire and also your existing students?
100%, yes.
Okay. And with respect to, my last question is with respect to this last attempt at the bond. I see that it's 54% yes, but it's a very small number of votes. Correct. I mean, like
Yes.
move around 25 people and you're at 55. Is that right?
That's correct.
Okay, I just wanted to point that out because it seems like the effort certainly that's been made on that end, and it sounds like you came up a little short. Was that, and I apologize for not recalling this, but was that vote on that bond before or after you got word that there would be displacement from the campfire?
That vote, I could be off a day or two, but basically 2 days prior to the campfire
Was the vote?
was the vote, yes.
Okay, so at the time that the voters made their votes on your last request for a bond, the campfire had not happened yet, so that presumably was not in the voters' minds when they
Correct. The campfire
made
had
that
not
vote.
happened yet.
Okay, thank you.
And I'll just
Thank
add
you.
to that,
Yep.
Assemblyman, that, I mean, it's a very small, both of these areas are small school districts. So really, any amount of impact is going to be probably more greatly felt, if you will. And so you got both Gridley and Biggs. They're, two communities that are basically right next to each other in southern Butte County. So.
Thank you. Senator Leyva?
Thank you, Madam Chair. I am new to the State Allocation Board, but I can't think of anyone that would qualify more for financial hardship assistance. It seems like you guys have done everything that you can possibly do. Do we need a motion?
We do need a motion
At the time that it's appropriate, I would move that we go with option one, because I think it would put a further hardship on the district to ask them to come up with matching funds at this time. So I will just throw that out for consideration to the board.
Thank you, Senator. Were there, Mr. Diaz, and then I'll entertain that motion. Thank you.
Thank you, Madam Chair. And thank you for coming to visit with us and, explaining kind of the situation. When we met, we talked about the different attempts to actually finance locally and trying to attempt to get matching dollars. I am curious, though. You said it was 4 times, right?
Yes, sir.
On the last try, most recent, I should say, because hopefully you'll go back for more and keep trying. You went for a higher amount. And can you explain sort of the rationale behind if you lost 3 times before, why not try to,
I can
convince the
explain
voters
that.
for a smaller amount?
So the first 2 times we lost, I was not the superintendent in the district. I've been there the last 8 years. So as I we lost the first time I was there, and then when we started having community stakeholder meetings, trying to engage our stakeholders and, here's our modernization plans, what's missing here, what would you like, what is important to you. One of the things that kept coming up was our elementary school, which is a TK-8 school, does not have a gymnasium type facility. So for their wintertime activities and stuff, they're in a very small multiple purpose room. So one of the items that kept coming up was, is there any way we can get a small gym for the elementary school? And it came up over and over again. So the increase in our bond was to look at trying to put in a small gym, thinking that was an item that had came up a lot from our stakeholders, that we might pull in some more yes votes. And we got more yes votes, just not enough.
Thank you.
You're welcome.
Thank you. Any other questions from the board? Mr. Kim?
It's a question to Ms. Silverman first. Should Biggs receive the funds, the pot of money is coming from the financial hardship funds, and that would be that much less money for school districts that already qualify as under financial hardship and have done all of these other criteria.
So the money would be coming from the modernization pot. So yeah, so they would meet the qualifications. The board approves them, and so they would again have their projects funded. So they would get their match as a result of that. So there would be less funds available from the modernization pot of funds.
Those schools already qualify under the financial hardship requirements. They're all free and reduced lunches, English learning populations and like. The other question I have is, generally speaking, I think we can all be very sympathetic to the school district and the situation you're under. I'm just wondering if we said yes in this case, what would be the policy argument to say no to other school districts in very similar situations? Unfortunately, we're going to have fires throughout the state. We're going to have other natural disasters like this. Neighboring schools, maybe in Chico and the like, how would we say no? Or would we say yes to those and then just deplete the funds for those schools that are already qualified?
Is that a question, Mr. Kim?
It's a rhetorical question.
Thank you.
I had an answer for you, but it might not be the right one.
Any other questions from the board? No? Any public comment? This is obviously very tough and a tough one for my second time. It is, all the victims of the Camp Fire and the families that have been displaced is obviously incredibly difficult. And we do have a process where the board gets to make decisions based on these special circumstances. And what I do want to say is that, and to Mr. Kim's point, to the extent that this were to pass today, and as the Department of Finance and having to look at the whole state, we will abstain from this appeal. But I do think it's important that we note for the record and for everyone to know that in no way would this be considered precedential in the future, that these special circumstances are in fact special. You've done the data, you have had 4 bond attempts. I hope that what the board's actions today will do will actually help the district understand the need for local matches and local bonds, because it is disappointing that many school districts go out, they increase their debt service, everybody in the district is paying for it. And I do think that there's a skin in the game argument that we all need to make in school construction, because there are finite dollars, and it's unfortunate because every time we make a decision for one district, there is another district that loses. So that is equally difficult. So I really, really want to make the point that this isn't precedential whatsoever, and that when someone looks at this later and comes to Mr. Patton, that this is seen as a consequence of the campfires and not a consequence of not being able to pass a bond to make the matching dollars, because I think that's a really important distinction in terms of the integrity of school financing going forward. So with that, we had a motion from Senator Leyva. Was there a second? Second. Ms. Jones, may we call the roll? Did you have a question, Senator Wilk? Did I cut you off?
No, I'm very excited to vote.
Okay, good. I'm sorry about that. Then may we call the roll, please? Yes.
Senator Wilk.
Aye.
Senator Leyva. Aye. Senator Roth. Aye. Assemblymember Nazarian. Assemblymember O'Donnell.
Come back to me.
Okay.
O'Donnell, aye.
Assemblymember Cunningham.
Aye.
Juan Morales.
Aye.
Cesar Diaz.
Aye.
Daniel Kim.
Nay.
Assemblymember Nazarian. Thank you.
Oh, wait,
You abstained.
thank you. Okay.
I'm sorry, that motion did carry. I'm sorry.
Yes. We have 7-1, and that motion carries. Thank you, and thank you for coming up here.
Thank you very much.
And good luck with the school year. So we're now moving to item 7 as the room clears out. To the administrative costs of the school facility program. Ms. Silverman.
Yeah, 2 more items. Hang in
Yay.
there. We're almost done. So just want to direct your attention to tab 7, page 261. We wanted to highlight that back in 2014, we had a reservation of funds for the administrative cost for the school facilities program. And at that time, Proposition 1D, we were nearly exhausted of the program funds. So Proposition 51 did pass. And again, we didn't have a set-aside reservation of the program funds to administer the program. It is uniquely not part of the Bond Act. So as a result, we wanted to highlight to the board that, guess what, we need to set aside some program funds. So we wanted to check in and just to realize that not only the program funds covers the program for us, the Office of Public School Construction, but it also covers the Department of Education and their ability to administer the program as well from their end, because they have a responsibility to review district sites, construction plans, and their approvals as well. And Controller's Office also has a part of that program as well. They also will have a new act to perform, is reviewing the local audits. They also disperses the funds back to the school districts as well. So as we dole out apportionments, so they have a role. And so when we reserved the reservations of funds back in 2014, we had a set reservation of $52 million. And that reservation was based on a declining workload. Well, that reservation didn't carry us through the 1920 budget year as anticipated. So not only we have an estimation for the next 3 years, but we also want to do an additional carve-out. So how does this work? We wanted, again, it's obviously a transparent process, but we also wanted to share with the board how the allocation would work. So if I can direct your attention on page 263. So we have 4 set of program funds available. That's new construction, modernization, career tech, and charter schools. So there was a $7 billion proposition, and so the spread would be 43% out of the 2 largest programs, new construction and modernization, and a 7% spread between the career tech and charter school program. So that represents how we would spread the administrative cost for our departments, Department of Education and Controller's Office. That's $17.2 million annually. Multiply that by the 3 years. There's also an offset for the school site utilization fund. We collect that for unused site fee. That's nearly about $4 million a year, and that is offset from the bond cost as well. So we do that prorated over the next 3 years. That's about $39.6 million for the program needs. Again, if we don't reserve these funds now, we will have no one to process these grants. So that's really important for us. And there's a shortfall for the anticipated budget year for 1920. That reservation, again, didn't carry us through. So we wanted to share with the board, there's $4.3 million that we do need for that anticipated year. So this coincides with the Budget Act. So we just don't carve out money. We work again with the legislature and the Budget Act to conform that act. So our recommendation is to have the board approve this reservation of funds for the $39.764 million plus the $4.3 million set aside. And we would post that to the status of funds. And again, the goal is to reserve these funds for the next few years so that way we can continue our program.
Great, thank you. Is there any public comment? We have a motion by Senator Roth. Is there a second? Second by Mr. O'Donnell. May we please call the roll?
Senator Roth?
Aye.
Senator Wilk?
Aye.
Senator Leyva? Aye. Assemblymember Nazarian?
Aye.
Assemblymember O'Donnell?
Aye.
Juan Morales?
Aye.
Cesar Diaz.
Aye.
Daniel Kim.
Aye.
Gail Miller.
Aye.
And that motion carries.
Great, thank you.
One more last item. Hang in there, we're almost done.
Yeah, we appreciate it. So the next item,
Is a career tech education future funding cycles. So can direct your attention to page 266. Proposition 51 had a $500 million for the career tech education program funds, and we had dispersed of 2 funding cycles for $250 million, and we still have $250 million less to allocate. So we wanted to highlight how do we proceed with the remaining program funds. So there's been a heavy interest in the program. So we had the last funding cycle was allocated in May for $125 million. The last remaining project did go out as part of the consent agenda. So with that, the program was established, and it had a number of different funding cycles, as I shared with you in the past. Some of the funding order was created, and the funds were divided among geographical locales and service regions. And the first 2 funding cycles were funded based on the service regions, where the funding order was determined by the CDE score and also the geographic locale. For each cycle since then, the projects were ordered by the Department of Education score and the geographical locale only. So between 2006 and 2014, there have been 3 funding cycles, and that was almost a $466 million distribution of funds. As I stated, Proposition 51, with the $500 million allocation of funds, again, the goal is to share with the board how do we proceed with the remaining $250 million. This program has been oversubscribed, so the last interest in the program, again, there was a 32% program grant allocation. What does that mean? That means we had an abundance of applications that came through the door, and we can only award only 32% of the program grants to those folks who did apply for the program. I know last month we didn't actually take an action item forward, but we did have a lot of interested parties speak to the board, and definitely had a lot of heart, and we really had a lot of concerns about what they had to share, and take that interest, with how we want to proceed in the future. So what we wanted to share with them was they actually had a lot of concerns about their scores and how in the process, and we wanted to share that, again, there's a public stakeholder meeting about how we proceed in the funding order and the funding cycle. So we definitely would like to take those comments and how we proceed in the future and how we disperse the funds. So again, the goal is to get as much stakeholder feedback and how we fund those projects in the future. So what we would like to share with those stakeholders is your score is important, and don't feel like you're left out, because you have an opportunity to keep your scores if you didn't change anything in your program. So you don't necessarily have to go to CDE to have a reevaluation of your program scores. So that's one thing we really want to highlight to you. But if you did have your program changed, then you really have to have your project reevaluated by the Department of Education and have it rescored. But again, the goal is with the last funding cycle is have the board adopt for $250 million and provide the 6th funding cycle and declare the application open, and that any applications that's not funded by the December 31st, 2021 will be returned without further board action. So we would like to proceed with that action.
great, thank you very much. We have a motion. I know we have 3 folks that want asked to speak at public comment. Please come on up. Emily Shair, Melanie Patterson, and Glenn Sparks. And if you could, again, state your name for the record. And we were really grateful to everyone that came last time and talked about the importance of this program. And Mr. Morales, while we're talking about this, obviously this is a joint program with CDE and the State Allocation Board. And we do just want to emphasize, I know you know how important this is, and you're part of the finance family, but it is, the timing of this program is incredibly important, that folks can get this money out the door. And I think we probably have a shared goal of making sure that what we can do, whatever we can to expedite the timing so that these folks can really start putting these funds to use, because they are so limited. But with that, please state your names again for the record.
My name is Glenn Sparks, Director of Adult and Career Education for Pleasanton Unified School District.
My name is Emily Shire, representing Santa Barbara Unified School District.
Melanie Patterson, Rockland Unified School District.
Great, thank you for being here. Ms. Shire, were you going to speak on behalf of everyone, or is everyone sharing comments?
Everyone is speaking for themselves.
Okay, great. Go ahead then, please.
Okay. Well, thank
And
you.
you have a motion and.
Thank you for your time, and I'll try to be brief.
Absolutely,
I
please.
appreciate staff's analysis too for the 250 million recommendation, round 6. To me, that makes a lot of sense. We put in 3 applications in Pleasanton to, revamp new facilities, and again, to scoring. And I know it's a human process, and things are all over the map a little bit. 2 passed. 1 did very well. 1 just passed, and the other one did not. It's a little tough because even though they're 3 different sectors and they're scored by 3 different set of folks in different buildings, they were done in collaboration because we're putting together a CT building, a dedicated CT building using district bond as a match. So it's interesting because there was such collaboration with the apps, yet the subjectivity to the applications was pretty wide. And so with respect to the staff analysis on the scoring, couple of things real quick. I appreciate not needing to resubmit if there is, in grant applications for a new score, for example, if there's no change in the application, the project score, and the project budget. But I'd almost think most, if not all, apps would have challenges with the project budget piece because of construction costs and all the changes. So that one, I'm not just clear on in terms of, 6 months go by and 20% increases in some cases for costs. So I would almost think that districts would send different types of figures in, perhaps, maybe not. So just a little more clarification on that would be helpful. And then the other thing is, does the districts say you have to reapply because you do have just enough difference or just enough tweaks 6 months to a year later? Then you run the risk of having lower scores. So do we take the bird in the hand of the 2 apps that passed with the scoring threshold? Or if there's slight tweaks to those apps, they could get looked at a whole different set? And I know it's very hypothetical and it's a human process and that could happen, but it seems like you're almost competing with what you have done. So if there was just a little bit more comment or thought given to the scoring process for the apps that met the scoring threshold, and we, unfortunately, even though 2 passing apps were part of the 150 or whatever, that did not get funded because we didn't make the top 70 or 72 for round 5. So just comments. We appreciate the creative thinking. Grateful that there's $250 million left, and we're going to keep swinging regardless. But it was a little frustrating to have 3 very, very similar applications be so widely scored.
Right.
Anyway, thank you for your time.
Thank you for your time. Mr. Morales, do you want to?
Yeah, really quickly, on the scoring, in terms of the scores and the applications submitted to our department, we do have 2 funding cycles that we review now under Prop 51, and I just want to clarify that, in terms of the scores that we provide, you can use the highest of the 2, I'm talking about the same application, and submit that score to OPSC for funding. So just make sure that that's clarified, that even though you may receive a lower score for one of the applications during a funding cycle, you can always use the highest to submit a funding request to OPSC.
Thank you.
Thank you.
And then,
Shire?
yeah.
Yes, thank you. I did want to state that Glenn, we haven't met before, so this is not someone that I've been in communication with, so I'm glad to see you here and contributing. And I also did want to mention that.
Just stating your name for the record.
Yes, I'm
please?
sorry. Yes,
Thank you.
my name is Emily Shire. I'm from Santa Barbara Unified, and I've been working with a variety of districts, over 20 districts, and I'm just acknowledging that I have not met or spoken with Glenn before. I did also want to just raise awareness that there were a few others who wanted to join us today, but because the recommendation came out on Monday evening at 8 p.m., there was some confusion about that, and people were under the impression that it had been pulled from the agenda, and so they were not able to come because they had changed plans at the end of last week. So I'm speaking on their behalf as well. I just wanted to bring that forward. And I am, as last time, I'm going to read this just to make sure that I get to all of it. All right.
But I am going to remind you guys that you have a motion and a second. So this is a situation of taking yes for an answer, but no.
Okay. All right.
But we do appreciate you coming all the way up here.
All right. I do appreciate the opportunity to address this board again today on behalf of the Santa Barbara School District, as well as over 20 other school districts I've been communicating with recently. I also appreciate the opportunity to meet with each one of you in the last 2 days, or your chief of staff or other representatives. Those conversations were an important part of this process and were brought to bear on what I'm going to share right now. And I'm here today for 2 primary reasons. Number one, to support the OPSC's recommendation to release $250 million in a 6th and final funding cycle for CT facilities funding under Prop 51, and encourage this board to support efforts to expedite this funding cycle to mitigate many of the concerns I have raised regarding the high-scoring applications that are currently unfunded. The second reason I am here is to emphasize the importance of reevaluating the funding model and to thank the OPSC for organizing a stakeholders meeting to take place on July 24th to discuss that funding model and explore possible options for changing it so that it functions more effectively. First, I want to speak to why it's important to release the $250 million in a sixth and final funding cycle and do whatever is possible to expedite this cycle and get the money out to school districts so they can move on projects as soon as possible. At the May 22nd SAB meeting, and even as recently as yesterday, I was proposing that we should allocate some of the remaining $250 million to capture some of the high-scoring projects currently on the unfunded list from the 5th funding cycle. I spoke with many of you about that. In the last 22 hours, however, I have had opportunity to speak at length with Lisa and Barbara from OPSC, as well as Juan Morales, Fred Yeager, and John Gordon from CDE, and I have a full understanding of the legal issues with this suggestion and why it is not possible to consider. And I wanted to just voice those, particularly because I spoke with members about this yesterday. I wanted to share with this board that there is a liability risk in doing what I proposed, because by allocating more money to projects that were submitted during the 5th funding cycle, that effectively extends the 5th funding cycle beyond the $125 million cap that was put into place previously. And that is a liability risk and was determined to be a liability risk by both legal counsel for the SAB and legal counsel for the CDE. And they did not confer with each other. So they independently arrived at the same conclusion that pursuing this course of action is not advisable under the law. And I thought that was important to share with you. I do want to thank the board members who are in support of that proposal and in support of the spirit of it, which was to both honor the high-scoring projects sitting in limbo, as well as to expedite the process of getting the funding out into the field. I would also like to share with you that both Lisa and Barbara from OPSC pursued this option and explored it, and that Juan, Fred, and John from CDE were very interested in pursuing it as well. I do think it's important to bring up that for the CDE, expediting the process in this manner was their preference. They would have loved and preferred and maybe even jumped for joy to see the money go out into the field to fund the high-scoring applications that their division has already meticulously scored, which, as we talked about, these are significant to review, and they're comprehensive and they take a significant effort to evaluate. So alas, or perhaps we should celebrate, both legal counsel gave a thumbs down to this course of action. And given that, the next best option is to approve the $250 million for the 6th and final funding cycle, and to reevaluate and possibly reform the funding model that will be utilized for the 6th funding cycle. Doing this will address many of the concerns I raised with you on May 22nd and in our meetings in the last 2 days. I was able to gain clarity through my meetings with some of you about the way changes to the funding model can be implemented. There were questions about whether this was possible to achieve for the 6th funding cycle, and it is. As I understand it, and Lisa and Barbara, you can correct me, of course, OPSC initiates this process, which they are doing, through the July 24th stakeholders meeting. Then OPSC would prepare a recommendation for the SAB to approve before implementation. And I want to thank you both, Lisa and Barbara, for your time, for speaking with me about your intention to perhaps even have a second stakeholders meeting after the July 24th meeting and prior to presenting a recommendation to SAB regarding the funding model. Also, thank you for explaining how it is possible to implement for the 6th funding cycle if there were changes. This is very important to many districts, and I'm glad that the funding model is going to be revisited, and I do expect a good turnout on the July 24th meeting. As some of you know, there are a variety of concerns that we had discussed in our meetings related to the funding model. One suggestion is to reevaluate town locales and perhaps reclassify them as rural so that they can be moved out of suburban category. Another suggestion is to allocate funds proportional to the number of applications submitted by each locale. And under that model, rural schools would only be competing against rural schools, suburban schools would only be competing against other suburban schools, et cetera. And of course, these are just two of many of the suggestions that stakeholders will bring forward at the July 24th meeting. And I plan to attend, and I look forward to participating. As board members, I appreciate your engagement and awareness of these issues, and I trust.
Could we just kind of keep it to the motion?
Yes.
Seems like we're getting pretty wide here.
Yeah, that's a fair point, Mr. O'Donnell. Do you want to wrap it up? Because again, you have a motion in a second.
Yes, actually, these final points are, I think, important.
So I think, Ms. Shire,
In a second.
I'm going to recommend that maybe we end it there. And Ms. Patterson, if you have any final comments?
Yes,
given
can I
the-
just say one final thing?
One final thing.
Yes, thank you. I'm glad that everyone is in support, and I really just want to emphasize that we need to expedite the process and the timelines to get the money out.
Absolutely. I think everyone agrees with you, so let's stop there. And then
Wonderful,
Ms.
thank you.
Patterson, You're
Thank
welcome.
you. I appreciate the motion and the second.
Thank
and
you.
we'll move on.
Thank you.
All right.
So we have Mr. Morales, may
Madam
we?
Chair, just a quick comment.
Yeah.
Because on OPSC's defense, the reason why the item was late is because we were working together on coming up with a proposal. And yes, we were exploring the possibility of using existing scores because we know that there's a lot of high-quality programs out there. As you noted, there are some concerns from legal counsel, not just the SABs, but from ours. That's why we have this option before you. So we thank OPSC for their patience, and we look forward to working together to jointly administer the program.
Great, thank you. I appreciate that. And to Ms. Silverman and Ms. Campbiner, thank you for taking the time to really expedite this program. So we have, I can't remember, we have a motion by Senator Roth and a second by Mr. O'Donnell. May we please, any other public comment? No, thank you. May we please take the roll on the $250 million allocation?
Yes. Senator Wilk.
Aye.
Senator Leyva. Senator Roth. Assemblymember Nazarian. Assemblymember O'Donnell. Juan Morales.
Aye.
Cesar Diaz. Daniel Kim.
Aye.
Gail Miller.
Aye.
And this motion carries.
Great, thank you very much, and thank you for being here. We have a final informational item by Ms. Silverman.
That's it. I'm not sure if the other members want to vote for the other open items, consent agenda.
Oh, we can. I think, are there members, if you voted on everything, please feel free to go. We have a couple items. We have,
The minutes for Senator Leyva, how do you vote on the minutes? How do you vote? Aye. Okay, thank you. And also, while I have you here, can you tell me how you vote on the consent? Aye. Okay, thank you. And then Assemblymember O'Donnell, I need your vote on the minutes
Aye.
and on consent.
Aye.
Okay, that wraps that up. Thank you.
great, is that everyone? Thank you very much. This meeting is adjourned.
What do I-
Thanks.